Good afternoon, everyone. So, today we have to discuss yet another and the most recent case from the Bombay High Court, which is Satish Ragde versus the state of Maharashtra. So, good afternoon, everyone. And the date of the judgment of this is 19 January 2021. After we had a lot of controversy over the definition of sexual harassment, especially with regard to its interpretation in the Prevention of Children from Sexual Offences Act, it was pertinent for us to discuss this case of Satish Ragde versus the state of Maharashtra. There was a huge controversy when one of the High Court judges in a POCSO case said that for proper sexual harassment to be constituted under Section 7 of the Prevention of Children from Sexual Offences Act, there has to be established a skin-to-skin contact with the victim of the sexual harassment. The perpetrator of the crime has to make a skin-to-skin contact with the victim. Only then the proper case of sexual harassment can be established under Section 7 of the POCSO Act. Since I have shared this PDF doc beforehand, I assume that all of you must have gone through it. You must have gone through it once, at least to know the nature of the case and the cases and the sections involved. So I guess and I assume that you must be having the bare text of the laws and the sections involved in the case. Okay. So this Satish Ragde versus the state of Maharashtra. This was the criminal appeal number 161 of 2020. Court, Bombay High Court, Bench, Justice Pushpa V. Ganediwala. Date of the judgment 19 January 2021. What happened in this case was, the case involves a 12-year-old girl who was sexually harassed. The circumstantial evidence as well as the testimony of the witnesses were taken into consideration by the Nagpur Joint Additional Sessions Judge. After recording his conviction under Section 342, 363 and 354 of the IPC as well as Section 8 of the POCSO Act, the special court sentenced the accused to 3 years of solitary confinement and a fine of Rs 1,500. So these are the sections involved. Section 7 of the POCSO Act, because Section 7 of the POCSO Act, it actually defines what is sexual harassment. Okay. And Section 8 of the POCSO Act tells or enumerates the punishment of sexual harassment committed under Section 7. Okay. So I'm reading this. The case involves a 12-year-old girl who was sexually harassed. The circumstantial evidence as well as the testimony of the witnesses were taken into consideration by the Nagpur Joint Additional Sessions Judge. After recording his conviction under Section 342, 363 and 354 of the IPC as well as Section 8 of the POCSO Act, the special court sentenced the accused to 3 years of solitary confinement and a fine of Rs 1,500. Okay. So I guess that you have read what is there under Section 7. So let us first read the sections. Okay, Section 7 of the Prevention of Children from Sexual Offences Act says, whoever, listen to me very carefully, whoever with sexual intent touches the vagina, penis, anus, or breast of the child, or makes the child touch the vagina, penis, anus, or breast of such person or any other person, or does any other act with sexual intent which involves physical contact without penetration, is said to commit sexual assault. Actually, these are the sexual assault, sexual offenses, or something called sexual harassment was not properly defined before 2013. Okay, there was simply an offense of rape or outraging the modesty of women under section 354 of the IPC. Okay, but post Nirbhaya scenario gave us the Criminal Law Amendment Act of 2013, which introduced something called sexual harassment. Okay, that even stalking, voyeurism, so offenses like stalking, voyeurism, or touching someone with a sexual intent has become an offense. Okay, so in POCSO also, this is what is known as sexual assault, that whoever with sexual intent touches the vagina, penis, anus, or breast of the child, or makes the child touch the vagina, penis, anus, or breast of such person or any other person, or does any other act with sexual intent which involves physical contact without penetration, is said to commit sexual assault. Okay, this is what section 7 is. Okay, this is the section 7 of the POCSO Act. Section 8 simply enumerates the quantum of punishment and the fine to be levied against the perpetrator. Okay, now facts of the case. On 14th December 2016, the prosecutrix, who was about 12 years old at the time, went to bring guava but did not return for a long time, prompting her mother to go out and look for her. Okay, like on 14th December 2016, the prosecutrix, who was about 12 years old at the time, she went out to take guava or to bring guava, but she didn't turn up for a long time. So this prompted her mother to go on a cui vivi and look for her. Okay, so she started searching out all around and she couldn't be found. Their next door neighbor informed the mother that she had witnessed the accused bringing the prosecutrix to his home and showed her around. Okay. When the mother arrived at the house, she inquired about her daughter's location, which the accused denied knowing. Okay. So their next door neighbor informed the mother that she had witnessed the accused bringing the prosecutrix to his home and showed her around. When the mother arrived at the house, she inquired about her daughter's location, which the accused denied knowing. The mother became suspicious and searched the accused's home. She discovered her daughter screaming in a room that was locked from the outside while checking the first level. She was taken outside by her mother. The prosecutrix was terrified, and she quickly told her mother about how the accused lured her into his house on the guise of giving her guava, touched her breast, and she screamed as he tried to remove her salwar. The mother immediately filed a police report against the accused. The charge sheet was filed before the special POCSO court in Nagpur after the police conducted an inquiry. So I hope the facts of the case are clear to you, because there's no rocket science involved, and the facts of the case are also not very complicated. They are like a very short story which encapsulates one of the biggest offenses ever, one of the most serious offenses ever. Have you understood the facts of the case? Have you understood the facts of the case?
A very short story which encapsulates one of the biggest offenses ever, one of the most serious offenses ever. Have you understood the facts of the case?
Okay. So most, yes, Prableen has also understood, Mehul has also understood, Soumya, Riyaz, Baat, Jazbaat, everyone has understood. Ananya, good. Okay. So this happened. Now the mother immediately filed a police report against the accused. The charge sheet was filed before the special POCSO court in Nagpur after the police conducted an inquiry. Okay. Now the special court, POCSO establishes a special court. Like within the district court, one judge, one room is designated as the POCSO court, and one of the judges of the rank of ADJ is designated as a special judge POCSO. Okay, so there is a special court that is known as a special court. Like it has to dispense cases only and only the POCSO cases. Okay, the special court found the accused guilty of outraging a girl's modesty, kidnapping, and unlawful confinement under sections 354, 363 and 342 of the IPC, as well as sexual assault under section 8 of the POCSO Act, and sentenced him to 3 years in prison and a fine of rupees 500. Okay, so what are the sections involved? Let us first read the sections. Laws applied. Section 7 of the POCSO Act, section 8 of the POCSO Act, section 342 of the IPC, section 354 of the IPC, section 361 and 363 of the IPC, section 313 of the CRPC, section 428 of the CRPC, and section 6 of the Indian Evidence Act. Okay, these are the laws and the sections involved in the case. Section 7, I have already told you that section 7 of the POCSO Act is simple, that whoever with sexual intent touches the vagina, penis, anus or breast of the child, or makes the child touch the vagina, penis, anus or breast of such person or any other person, or does any other act with sexual intent which involves physical contact without penetration. See, this is an underlining phrase of the whole paragraph, that without penetration, because if penetration occurs, it is simply a rape. So it has to be without penetration, and this is said to and the person is said to commit sexual assault. So this is section 7 of the POCSO Act. Section 8 simply enumerates the quantum of punishment of the sexual assault defined under section 7. Section 342 is simply the punishment for the wrongful confinement. I assume that you know what is wrongful restraint and wrongful confinement. Section 354 of the IPC is what? Section 354 of the IPC is outraging the modesty of a woman. Okay, if somebody indulges in outraging the modesty of a woman, he simply has to be punished. Like 354 defines outraging the modesty of women and also contains the quantum of punishment. Section 361 and 363 of the IPC. 361 is simply the kidnapping from lawful guardianship. Like if any minor who is under if a female under 16 years of age or a male under 18 years of age takes away or entices any female under 16 or any male under 18 years without the consent of such lawful guardian, then he is said to commit kidnapping from lawful guardianship. So this is section 361 of the IPC. Section 363 simply enumerates the punishment for kidnapping from lawful guardianship. Okay. Now tell me, what is section 313 of the CRPC? What is section 313 of the CRPC? This is simply the power of the court to examine the accused Power of the court to examine the accused at any stage of the trial. Okay. Power to examine the accused. Like when the trial is going on, the court has the power to examine the accused as and when the court deems it fit and necessary to examine or put some questions to the accused, because sometimes the trial comes at a point where some questions are inevitable and they are supposedly to be asked by the court from the accused. Okay, so power to examine the accused, subsection 1. I'm reading section 313. Yes, Mehul. Yes, Prablin, examination of the accused. Section 313, power to examine the accused. Subsection 1. In every inquiry or trial, for the purpose of enabling the accused personally to explain any circumstances appearing in the evidence against him, the court A. may at any stage, without previously warning the accused, put such question to him as the court considers necessary. B. shall, after the witnesses for the prosecution have been examined and before he is called on for his defense, question him generally on the case, provided that in a summons case where the court has dispensed with the personal attendance of the accused, it may also dispense with his examination under clause B. So the court in every inquiry or trial is empowered to examine the accused personally to explain any circumstance which is appearing in the evidence against him. For example, if the prosecution has given any evidence and if it is incriminating the accused, then the court may ask the accused to explain it. Okay, what led to such circumstances? Or the court may at any stage without previously warning, like the court is not required here to give a previous warning to the accused that from the next date I'm going to examine you. No, without previously warning the accused, put such question to him as the court considers necessary. And B. shall, after the witnesses for the prosecution have been examined and before he is called on for his defense, question him generally on the case. Okay. Now, subsection 2. No oath shall be administered to the accused when he is examined under subsection 1. It's not necessary to examine him on the oath. Oath is not necessarily to be administered. 3. The accused shall not render himself liable to punishment by refusing to answer such questions or by giving false answers to them. Like this, subsection 3 of section 313 of the CRPC stands in consonance with Article 20 of the Constitution of India, Article 20 clause 3 of the Constitution of India, which gives everyone the right against self-incrimination. That if somebody is refusing to answer some questions, if the accused is refusing to answer some questions, he shall not be liable to punishment for refusing to answer or giving false answers to them. Okay, if the accused is simply giving false answers, then he shall not be liable to punishment if it is on later stage it is discovered that all the answers were false and he was lying or he refused to answer all the questions put by the court. So this is like this falls in consonance with section Article 20 clause 3 of the Constitution of India, which contains right against self-incrimination. Okay. Subsection 4. The answers given by the accused may be taken into consideration in such inquiry or trial and put in evidence for or against him in any other inquiry into or trial for any other offense which such answers may tend to show he has committed. Okay. The court may take help of prosecutor and defense counsel in preparing relevant questions which are to be put to the accused, and the court may permit filing of written statement by the accused as sufficient compliance of this section. So this is section 313 of the CRPC, that the court would have examined the accused in this case. And what is section 428 of the CRPC? What is section 428? Period of detention undergone by the accused to be set off against the sentence of imprisonment. Like for example, if as an under trial prisoner, if any accused has already served a considerable number of years in imprisonment and like after serving the imprisonment as an under trial prisoner, if he is found guilty by the court and is pronounced punishment for the next 5 years, for example, then if he has already served 2 years, then the 2 years will be set off against the sentence of imprisonment, and he shall be kept only for 3 years behind the bars. Like जितना भी वक्त उसने जेल के पीछे गुजार दिया है एज एन अंडर ट्रायल प्रिजनर्स, वो टोटल पनिशमेंट में से माइनस कर दिया जाएगा. ओके, आई एम रीडिंग दिस सेक्शन 4. Yes, Baat Jazbaat Uttam and Mehul Ga is they are also already commenting. Period of detention set off against sentence of imprisonment. Period of detention undergone by the accused to be set off against sentence of imprisonment. Yes, where an accused person has on conviction been sentenced to imprisonment for a term not being imprisonment in default of payment of fine, the period of detention, if any, undergone by him during the investigation, inquiry or trial of the same case and before the date of such conviction shall be set off against the term of imprisonment imposed on him on such conviction, and the liability of such person to undergo imprisonment on such conviction shall be restricted to the remainder, if any, of the term of the imprisonment imposed on him. So like only the remainder punishment will be given. Like for example, if he is accused in a case which is punishable with 5 years of imprisonment, and as an under trial prisoner he has already served 2 years behind the bars, then after 2 years, if the court finds him guilty and pronounces the 5 years punishment or 5 years of imprisonment to him, then it's not that even after serving 2 years as an under trial prisoners behind the bars, he is going to serve yet another 5 years. Then that will be 7 years, and this is going to be not justified. Okay, not justified. Then in this case, 5 years from out of this 5 years punishment, 2 years will be deducted and the remainder punishment will be given. Like he has to stay for the next 3 years and he will come out and it shall be deemed as if he has served 5 years fully. And that is what actually is the situation, that he has already served 5 years, only then he is going to come out. So this is what section 428 of the CRPC is. Why section 313 and 428 of the CRPC are involved? Obviously because it's a criminal case, and this would have happened that the accused would have he was examined by the court and he served a good number of years behind the bars as an under trial prisoner, and later on he was found guilty. So then section 6 of the Indian Evidence Act. What is section 6 of the Indian Evidence Act? I guess we discussed it in the last lecture. Yesterday only or the day before yesterday, I don't remember exactly, but I remember that we discussed section 6 of the Indian Evidence Act. It is known as what? Section 6 of the Indian Evidence Act is technically known as what? Res gestae. Very good. Ananya, Jazbaat, Prablin. Hearsay evidence. No, Prablin. Make sure that you do not confuse between res gestae and hearsay evidence. They cannot stand on the same pedestal. No. Yes, relevancy of facts may hold, forming part of the same transaction. Yes, Ananya, Devilal case. Relevancy of facts. Only those facts are relevant which are so immediate after the crime has happened, and like whatever was said or done or seen by the bystanders immediately after the crime was committed, like they were so immediate as to form part of the same transaction. They were so immediate that they almost become a part of that transaction only, so they become relevant. It is not a hearsay evidence. It is not a hearsay evidence, Prablin. Make sure that you understand, all of you must understand the difference between hearsay evidence and res gestae. Res gestae serves as an exception to the hearsay evidence. Hearsay evidence is suni sunai baatein, and hearsay evidence happens over a period of days or over a period of time. Okay, over a period of time it happens. Like hearsay evidence is whatever was said or done by other people after the transaction had occurred and much time had passed after the transaction had completed. So hearsay evidence takes place after a period of time, but whatever is done immediately after after the crime is committed as to form part of the same transaction is not hearsay evidence, and it is relevant and it is admissible in the court. So this is known as res gestae, section 6 of the Indian Evidence Act. Okay. Okay. Yes, everyone is right. Okay, Prableen. Okay. Immediate effect, yes. Contentions made by the petitioners. The appellants, now the petitioners in this case, who was the petitioner? Who was the appellant? Who made an appeal? The accused, like Satish Ragde, the appellant. The appellant's accused counsel aggressively opposed the underage girl's mother's testimony. He said she was a hearsay witness who had not personally witnessed the occurrence. As a result, her testimony may have some flaws that lead to the conclusion that the crime was not done in a cruel manner. Actually, the girl's mother's testimony, mother of the victim's mother's testimony was recorded by the Sessions Court, and it was admitted as a relevant fact under Section 6 of the Indian Evidence Act. Under Section 6 of the Indian Evidence Act. But in this case, the counsel for the appellant aggressively opposed the mother's testimony because he said it was completely a hearsay evidence and it could not fall within the ambit of Section 6 of the Indian Evidence Act, because when she went out to look out for her daughter, and she was then told by her next door neighbor that someone in the house has brought her in, okay, and she has seen her. Then she went inside the house and then she discovered her daughter. Okay, so whatever was seen or heard by the victim's mother do not form part of the same transaction, and therefore it was not relevant under Section 6 of the Indian Evidence Act. This was the contention of the petitioners. This was what the advocate of the appellants was arguing before the Bombay High Court while making an appeal. Okay, have you understood this? So he also disputed the girl's mental competence, which the learned trial court noticed when recording her testimony. He claimed that the small girl's behavior indicated that she lacked mental competence. So, like every counsel would do in this case, is to challenge the girl's mental competence, that she was too immature to understand that what had happened with her, and that she was not narrating the facts or the incident or the entire trail of events which had occurred with her properly. So girl's mental competence was challenged by the appellants, which the learned trial court noticed when recording her testimony. He claimed that the small girl's behavior indicated that she lacked mental competence. Okay, the appellant's counsel argued that the prosecution proven conduct of pressing of breast does not fall within the ambit of sexual assault under Section 7 of the POCSO Act. The prosecution does not contend that the appellants took off her top and touched her breast. As a result, there is no direct physical contact, that is a skin-to-skin contact with sexual intent that does not result in penetration. Okay. So the appellant's counsel argued that the prosecution proven conduct of pressing of breast does not fall within the ambit of sexual assault. Okay. Now the appellants contended that the counsel for the appellant said that the prosecution said that the accused pressed the victim's breast. Okay. And pressing of the breast does not fall within the ambit of sexual assault under Section 7 of the POCSO Act. Okay. Because under Section 7, if the like if the child is made to touch the vagina, penis, anus or breast, then their contention was that for touching these kinds of things there has to be a skin to skin contact, like the cloth should not come in between. So the prosecution does not contend, this is what the appellants were saying, like this is the most despicable, the most disgusting argument ever, that for establishing sexual assault there has to be a skin to skin contact. Like if somebody is pressing the breast, then that does not amount to sexual assault. This is the most disgusting argument ever. Like personally I feel this is the most disgusting thing ever. The prosecution does not contend that the appellant took off her top and touched her breast. So they were trying to say that the prosecution did not say this, that her top was taken off, okay, and then he touched her breast. As a result, there is no direct physical contact. There has to be a direct physical contact, that is a skin to skin contact with sexual intent that does not result in penetration, okay. These were the contentions made by the petitioners. Now the contentions made by the respondents. The testimony of the three witnesses, namely the minor girl, her mother and their neighbor, was presented by the state's counsel. Okay, when the minor and her mother testify about the incident, it is clear that both agree that the appellant touched the prosecutrix's breast and attempt to remove her salwar. Okay, the testimony of the three witnesses, namely the minor girl, her mother and their neighbor, was presented by the state's counsel. When the minor and her mother testify about the incident, it is clear that both agree that the appellant touched the prosecutrix's breast and attempted to remove her salwar. Right? Have you understood this or not? The state was trying to produce the testimony of the three witnesses, the minor girl herself, her mother and the neighbor. Okay, the minor and the mother testified about the incident, and it is clear that both agree that the appellant touched the prosecutrix's breast. The minor girl herself was saying that the accused touched her breast, mother was saying that the accused touched her breast and attempted to remove her salwar. So he also read from section 7 of the POCSO Act, which defines sexual assault, which makes it obvious that a physical touch with sexual intent without penetration is a required element of the crime. Furthermore, on the basis of the idea of agisdem generis, the phrase any other act encompasses the types of acts that are equivalent to the activities expressly listed in the definition. Like, what do you want to establish? As a state counsel, the advocate was trying to ask the appellants that what are they trying to establish? Are they trying to say that the elements of the crime only involves a skin-to-skin contact? Or does the definition under section 7 expressly says that there has to be a skin-to-skin contact to establish the sexual assault under section 7? Or what are they trying to say? Because any activity, it's written simply there, like, what do you think? Sexual assault cannot take place without removing the clothes. It can take place. Like if somebody is touching the vagina, penis, anus or breast from above the cloth, without removing the cloth, and there is no direct skin to skin contact, don't you think it is a sexual assault? It still constitutes a sexual assault. Yes, it does. It does. Furthermore, I don't know what the court found in its judgment, but what I personally feel is that there establishes the crime of sexual assault right then when there is a touch with a sexual intent. So furthermore, on the basis of the idea of agisdem generis, the phrase any other act encompasses the types of acts that are equivalent to the activities expressly listed in the definition. The next act should be of a similar nature to the preceding one. As a result, the accused's actions came within the scope of section 7 of the POCSO Act, and he should be penalized for sexual assault under section 8 of the POCSO Act. Okay. Now let us read the issues raised. There are 3 issues. Okay. Have you understood the contentions of the petitioner and the respondents? First, you make me this clear. That have you understood the contentions of the appellants and the respondents?
Under Section 8 of the POCSO Act. Okay. Now let us read the issues raised. There are three issues. Okay. Have you understood the contentions of the petitioner and the respondents? First, you make me this clear. That have you understood the contentions of the appellants and the respondents?
Okay. Mehul, Jazbat, Ananya, Prasida, everyone has understood. I assume everyone else has also understood. Okay, now let us read the issues. Okay, Riaz. Whether the accused shall be held guilty for sexual harassment under Section 7 and 8 of the POCSO Act. Whether the accused shall be held guilty for sexual harassment under Section 7 and 8 of the POCSO Act. ओके सबसे इंपॉर्टेंट इशू यहां पर यही था, क्या अक्यूज्ड को सेक्सुअल असॉल्ट के लिए गिल्टी ठहराया जाए अंडर सेक्शन 7 and 8 of the POCSO Act. 2. Whether pressing prosecutrix breast without having a skin to skin contact can be considered under the definition of sexual assault provided in Section 7 of the POCSO Act and punishable under Section 8 of the POCSO Act. Like, I don't understand why this issue was even made and by the court that there has to be a skin to skin contact. Like, this is the most unusual thing ever. Like, what would you call a crime where someone touches the victim without removing her clothes with a sexual intent? What will you call it then? If you don't call it, and if you don't agree to call it a sexual assault, what will you call it then? That is the question. Will you wait for the skin to skin contact to happen? Like, whether pressing prosecutrix breast without having a skin to skin contact be considered under the definition of sexual assault provided in Section 7 of the POCSO Act and punishable under Section 8 of the POCSO Act. Okay, then issue 3, whether attempt to remove salwar of the prosecutrix would fall within the definition of sexual assault as defined under Section 7 and punishable under Section 8 of the POCSO Act. Okay. Now, this was an attempt to remove salwar. Like, this, even if an attempt was made to remove her salwar, then that was done with a sexual intention to touch her vagina, right? This was what the accused was wanting. Mohammed Riaz is saying court should not have entertained such argument in the first place. Yes, that's what even I strongly believe, that this argument should not have accepted. Not even Section 7 does not expressly lays this condition that there has to be skin to skin contact. And secondly, this attempt to remove salwar, even if there is an attempt to remove salwar, it establishes the sexual intent of the accused to touch the vagina of the victim. This is so simple. There's no rocket science involved. If the accused had enticed, he first enticed the minor girl under the guise of giving her guava. She was taken away and she was kidnapped from lawful guardianship because she was 12 years old. Okay, So this was the first crime. This was the first crime the accused committed. Then she was taken inside a room and she was locked up there, like she was confined. So the second crime that happened in the chain of events was the wrongful confinement. Okay. Then Mehul is commenting. Okay, let us first, you listen to me what I am trying to say. The second crime that was committed in the chain of events was the wrongful confinement. Then he tried to outrage her modesty. So that was outrage her modesty because he then came closer to her. Okay, closer to her, and he was like trying to touch her or outrage her modesty. So the third crime that was committed in the chain of events was under section 354 of the IPC, that is outraging modesty of the woman. Okay, outraging modesty of a woman. Then fourth, then he pressed the prosecutrix's breast and then attempted to remove the salwar. Don't you think the entire series of events in this case firmly establishes the sexual intent of the accused to touch the vagina of the prosecutrix and commit the rape? If her mother would not have gone out for her lookout, and her next door neighbor would not have told her mother that she saw her daughter going inside a house with the accused, then this would have, God forbid, this would have unfortunately this would have the proper rape would have happened in this case. Don't you think the entire chain of events firmly establishes the sexual intent of the accused? It does. And still these kinds of issues are being discussed before the court. Whether in order to establish sexual assault, there has to be a skin to skin contact, and there's this attempt to remove salwar. What do you think? Attempt to remove salwar should not be punishable under section 7. It should be punishable, because at least it establishes the sexual intent of the accused. And once the sexual intent is established, crime is fully completed under section 7 of the POCSO Act. Sorry. So these were the issues that were taken up before the court. Now let us read the decision of the court. Perhaps, I guess you all must be intrigued to know what the decision of the court was. Okay. The Honorable Court stated that the learned counsel was unable to prove from the record that the minor girl's mother and the little girl's evidence could not be considered, or that they were not competent witnesses. The girl's responses to the questions were not irrational. Furthermore, she informed her mother about the incident as soon as it occurred, and the first information report was filed as a result. Both mother and daughter's testimony are consistent and valid under Section 6 of the Evidence Act, implying that the res gestae principle would apply. Okay, so first of all, the question was regard to the decision was of the court was regard to the testimony and relevancy of the veracity and the authenticity and relevancy of the mother's testimony. That whatever was immediately narrated by the victim right after coming out from the room where she was confined, when she narrated the entire trail of events to her mother, will this be constituted as a hearsay evidence? Because whatever mother told to the police and which was converted into an FIR, can it be constituted as forming part of the same transaction, or was it just a hearsay evidence? So the entire chain of events was so subtly connected that there were no gaps. The victim immediately came out and she narrated the entire incident immediately. There was no gap. Whenever there is a gap, we can say that this is a hearsay evidence. This is a hearsay evidence. But all the narrations took place without a gap. So it was not a hearsay evidence. It was relevant under Section 6 of the Indian Evidence Act because it was so immediate that it formed part of the same transaction. So the Bombay High Court was also of the view that the learned counsel was unable to prove that the testimony of the mother and the testimony of the victim herself were not relevant. Okay, and they were not competent witnesses because the girl's responses to all the questions were not irrational. Furthermore, she informed her mother immediately as soon as it occurred about the incident, and immediately the mother filed the first information report as a result. And both mother's and their daughter's testimony are consistent and valid under Section 6 of the Evidence Act, implying that the res gestae principle would apply here. Have you understood this issue? Have you understood this issue? देखिए, for example, you are the defense counsel or you are the counsel in any of the criminal case, for example, and you are supposed to defend someone, and if you want to rebut any of the evidence given by the opposite counsel under Section 6 of the Evidence Act, how will you prove it as a hearsay evidence? You will have to prove that whatever was said or done was after a considerable period of time and there was a gap. Okay, there was a time gap. And wherever there is a time gap in the transfer of events, in the narration of events, then it can be said that it is a hearsay evidence. There was no gap. Okay, there was no gap. Why hearsay evidence is not admissible in the court? Because hearsay evidence is mostly said to be tampered and tutored. Because if you are narrating some incident after a very long time or after 2 days or 3 days, for example, then you cannot narrate it in a way that you could have done it exactly after the incident. Okay, because after a days of you, it becomes the whole picture of the incident becomes stale. Okay, it becomes stale and unfresh, and you cannot narrate it in the manner you could have narrated exactly after the incident. So that is why hearsay evidence is not admissible in the court. But in this case, there was no time gap. So have you understood this, the logic and the application of Section 6? Have you understood this?
It becomes stale and unfresh, and you cannot narrate it in the manner you could have narrated exactly after the incident. So that is why hearsay evidence is not admissible in the court. But in this case, there was no time gap. So have you understood this? The logic and the application of Section 6. Have you understood this?
Okay, Prasida, you have understood? Okay, now moving ahead. The court further reasoned that, according to the definition of sexual assault, a physical touch with sexual intent without penetration is a crucial component of the crime, and that more proof and more serious claims are required. Okay. The court further reasoned that, according to the definition of sexual assault, a physical touch with sexual intent without penetration is a crucial component of the crime, and that more proof and more serious claims are required. Okay. The court further observed that it is uncertain whether the accused removed the top of the prosecutrix or inserted his hand while grabbing her breast, indicating that there was no direct physical contact or skin to skin contact between the accused and the victim as defined by Section 7 of the POCSO Act. The act perpetrated by the accused appears to come under Section 354 of the IPC, definition of outraging the modesty of a woman. The accused was found not guilty under Section 8 of the POCSO Act and was sentenced to 1 year in prison and a fine of Rs 500 for outraging the prosecutrix's modesty and illegally confining her under Sections 354 and 342 of the IPC. In addition, the accused was served with a non-bailable warrant. Now, I mean, this judgment of the Bombay High Court by Honorable Judge Justice Pushpa V. Ganediwala, this was like so vociferously and vigorously attacked by people from different walks of life, especially the judges, the lawyers, and other people from the legal fraternity. The Supreme Court took cognizance of this case because this was seriously mocked upon, that a judge who happens to be a judge of the High Court is sitting there and is giving this judgment that for constituting a crime under Section 7 of the POCSO Act, there has to be a skin to skin contact. Like, are you waiting for the accused to do that? Seriously. The court further reasoned that according to the definition of sexual assault, a physical touch with sexual intent without penetration is a crucial component of the crime, and that more proof and more serious claims are required. What do you want when you are accepting the testimony of the mother and the victim herself under Section 6 of the Indian Evidence Act, and there is an established proof that this sexual assault has taken place because the next door neighbor of the mother has also given her testimony stating the same exactly what the mother and the victim herself said, was enough to establish the crime. But still, you are accepting this fact that the sexual assault has taken place. You are accepting that she has outraged her modesty under Section 354 of the IPC. You are accepting that he has kidnapped her from the lawful guardianship. You are accepting that he confined the victim inside a room, but you are not accepting this, that there was a physical touch with sexual intent only because her clothes were not removed. He attempted to remove the salwar, but salwar could not be removed. He attempted to press the prosecutrix's breast, but it was done from over and above the cloth. This is something which is highly unbecoming for in today's century and in today's world where we are so conscious and particular about the sexual crimes. We cannot buy this definition. Right. So the court further reasoned that according to the definition of sexual assault, a physical touch with sexual intent without penetration is a crucial component of the crime, and that more proof and more serious claims are required. The court further observed that it is uncertain whether the accused removed the top of the prosecutrix or inserted his hand while grabbing her breast. Like, she was trying to find out that if this was done, only like if the judge was trying to find out that she is going to punish the accused only if this has happened, indicating that there was no direct physical contact or skin to skin contact. Do you really see this offense this way? Like, do you wait, or what do you want for the accused to do? Do you want the accused to establish a skin-to-skin contact to get him prosecuted under Section 7 of the POCSO Act? Like, this was the observation of the Bombay High Court, quite surprisingly and unfortunately. This came out to be one of the judgments of the Bombay High Court. The court further observed that it is uncertain whether the accused removed the top of the prosecutrix or inserted his hand while grabbing her breast, indicating that there was no direct physical contact or skin-to-skin contact between the accused and the victim, as defined by Section 7 of the POCSO Act. The act perpetrated by the accused appears to come under Section 354 of the IPC's definition of outraging the modesty of a woman. The accused was found not guilty under Section 8 of the POCSO Act and was sentenced to 1 year in prison and a fine of rupees 500 for outraging the prosecutrix's modesty and illegally confining her under Section 354 and 342 of the IPC. In addition, the accused was served with a non-bailable warrant. Okay, so this is all about today's case. Now, any questions?
Perpetrated by the accused appears to come under Section 354 of the IPC's definition of outraging the modesty of a woman. The accused was found not guilty under Section 8 of the POCSO Act and was sentenced to 1 year in prison and a fine of rupees 500 for outraging the prosecutrix's modesty and illegally confining her under Section 354 and 342 of the IPC. In addition, the accused was served with a non-bailable warrant. Okay, so this is all about today's case. Now, any questions?
Yes, Ankita, obviously POCSO is a different law, is a separate law, is a special law. So the punishment will be separate, na?
Yes, and obviously POCSO is a different law, is a separate law, is a special law. So the punishment will be separate now.
Chitralekha is commenting also under Section 42 of the POCSO Act mandates a course of greater punishment in consonance with the statute prescribing such punishment. Yes, when the accused is found guilty, very good observation, Chitralekha. When the accused is found guilty of an offense punishable under two different sections of two different statutes, that is IPC and POCSO, greater punishment is prescribed. Obviously, all the punishments from the IPC and all the punishments from the POCSO together of the offenses will be combined and a greater punishment will be given. Here all the punishments of the POCSO were kept aside and only the punishment for outraging the modesty, including adding it to like the punishment for kidnapping, the punishment for wrongful confinement, all were added and they were simply came out to be 1 year in prison. Okay. So now, any other question?
And all the punishments from the POCSO together of the offenses will be combined and a greater punishment will be given. Here, all the punishments of the POCSO were kept aside.
Yes, this is a High Court judgment, Ankita.
Yes, this is a High Court judgment.
Yes, Chitralekha, the Supreme Court later on overruled this High Court judgment. Any other question? So I guess no more questions. And I am signing off then.
Yes, Chitralekha, the Supreme Court later on overruled this High Court judgment.
No, Lipsa Chaudhary, did they accept the punishment given by the High Court? They enhanced the punishment. The Supreme Court enhanced the punishment and said that this observation of the High Court, the called this is skin to skin contact wala jo observation tha Bombay High Court ka, that was overruled by the Supreme Court. And obviously the punishment was enhanced because they must have added to the punishment of the POCSO also, right?
Lipsa Chaudhary, did they accept the punishment given by the High Court? They enhanced the punishment. The Supreme Court enhanced the punishment and said that this observation of the High Court, this is skin to skin contact wala jo observation tha Bombay High Court ka, that was overruled by the Supreme Court. And obviously the punishment was enhanced.
Any other question?
They must have added the punishment of the POCSO also, right? Any other question?
Okay, then I'm signing off. Thank you all. See you tomorrow. Bye bye.